Hi, everyone. Thank you for joining us. Those that are in the room and those that are connected, we need a couple more minutes so for people to connect. But I just wanted to make a brief intro and welcome Rebecca Cook to the O'Neill Institute. Welcome back. I mean, Rebecca is a part of the Institute since the very beginning. It's been engaged in a lot of our projects and work, but it's great to have her back. And today we just have a panel, and I'll let Ivonne explain in more detail the idea of the discussion of the panel. I also wanted to thank the entire team at the O'Neill Institute that has been working and supporting the work in El Salvador, that supported the Amicus and all the work we've been doing. So we're very excited. This is a timely debate of a case that hopefully will be decided soon and with a very positive sort of outcome, but I'll let the experts and the panelists discuss that. So now I'm just going to pass it over to Ivonne Garza, who's going to kind of introduce the panel and the context of the case and the panelists.
Thank you, Oscar. So as Oscar said, good morning, everyone, and welcome to all of you joining us here in person and online through our platforms. We are more than delighted to host this panel today with wonderful speakers, and this panel is entitled Defending Sexual and Reproductive Rights, Amici Curiae in the case of Beatriz and others against El Salvador. And for this discussion, as I said, we have two wonderful speakers today, which it is my honor to present. First, Dr. Rebecca Cook. She is a professor emerita in the Faculty of Law, the Faculty of Medicine, and the Joint Center for Bioethics at the University of Toronto, and co-directs the International Reproductive and Sexual Health Law Program at the same university. She is the Legal and Ethics Issues co-editor of the International Journal of Gynecology and Obstetrics, and serves on the editorial advisory board of Human Rights Quarterly. Her published books include Abortion Law in Transnational Perspective, Cases and Controversies, Human Rights of Women, National and International Perspectives, and Gender Stereotyping, Transnational Legal Perspectives. She is a member of the Order of Canada, a fellow of the Royal Society of Canada, and the recipient of the Certificate of Recognition for Outstanding Contribution to Women's Health by the International Federation of Gynecology and Obstetrics. Thank you for joining us today, Dr. Cook.
One thing we need to highlight, I mentioned that before, that Rebecca is also a Georgetown Law grad from the JD program. So that's something that...
Yeah, so it's wonderful to have you back here at Georgetown as a Georgetown alumni, and we're delighted to have you here. In addition, we also have Silvia Serrano Guzmán. Silvia co-directs the Health and Human Rights Initiative here at the O'Neill Institute and is an adjunct professor of law at Georgetown University. Silvia obtained her law degree in Colombia in Universidad Autónoma de Bucaramanga, and she also holds an LLM in International Legal Studies with a certificate in International Human Rights Law from Georgetown University Law Center, and an MA in Legal Argumentation from the University of Alicante. She is currently pursuing her SJD at Georgetown University Law Center, and prior to joining the O'Neill Institute, Silvia was an attorney at the Executive Secretariat of the Inter-American Commission on Human Rights, where she managed the merit stage cases regarding member states of the Organization of American States and supervised the preparation of reports on the merits. She was also responsible for the litigation of cases submitted to the Inter-American Court of Human Rights. Thank you also, Silvia, for joining us today. And before we begin, I would like to remind all participants who are joining us online and here in person that we will have a Q&A session after both of the panelists finish their presentations. And we can receive your questions through the Q&A tool that you can locate here in the Zoom platform. So please send us your questions online, and we will also be receiving questions here from our public today. And before we begin, I would like to give and provide our public a brief overview of the facts of the case that we're discussing today, Beatriz against El Salvador, and explain the Amici Curiae figure before the Inter-American Court of Human Rights. So with regards to the case, it is important to know that in February 2013, Beatriz, a young Salvadorian woman living in a situation of extreme poverty, was diagnosed with a high-risk pregnancy and with fetal anencephaly, which implied the extrauterine non-viability of the fetus. The medical committee of the Rosales National Hospital in El Salvador recommended a termination of the pregnancy to safeguard her health and life, which were in special danger since she suffered from systematic lupus erythematosus, lupus nephritis, and rheumatoid arthritis. However, Beatriz was denied the termination of her pregnancy due to the absolute ban on abortion in El Salvador. On April 2013, Beatriz and her legal representatives petitioned through a habeas corpus the interruption of the pregnancy. On May 2013, the Salvadoran Supreme Court denied the habeas corpus on the basis that authorities had not been omissive or generated a significant risk to the life and health of Beatriz. After 3 months of fighting within national and international courts, both the Inter-American Commission and the Court of Human Rights granted measures. The Inter-American Court of Human Rights granted precautionary measures and ordered the state to take the measures necessary to protect the life, health, and personal integrity of Beatriz. After she started with contractions on June 3rd, 2013, a cesarean section was performed. In November 2013, representative organizations filed a petition with the Inter-American Commission on Human Rights against the state of El Salvador for the violations of the human rights of Beatriz and her family. The commission then ruled on the admissibility of the case and issued recommendations on its merits. In January 2022, the case was presented before the Inter-American Court of Human Rights. The court held a public hearing on the case last week, hearing the testimonies of Beatriz's mom, doctors, and expert witnesses. As we can observe, the case of Beatriz presents an opportunity for the Inter-American Court of Human Rights to address the legality of total bans on abortion under international human rights law. It is expected that the court will rule on this case by the end of this year. Today, both Rebecca Cook and Silvia Serrano will explore the different arguments presented in their respective amicus briefs to the court. And just to give also an introduction on amicus briefs and why are they presented to the Inter-American Court of Human Rights, the rules of procedure of the Inter-American Court of Human Rights define amicus briefs through its Article 2 as the person or institution who is unrelated to the case and to the proceeding and submits to the court recent arguments on the fact contained in the presentation of the case or legal considerations of the subject matter of the proceeding by means of a document or an argument presented at the hearing. An amicus curiae can help the court in its decision. Furthermore, Article 42 of the same rules of procedure of the Inter-American Court of Human Rights establishes that amicus briefs can be presented by any individual organization to the court during the process up until 15 days after the public hearing of the case. The briefs, along with its annexes, must be written in the language of the casework and must include the name of the author or authors and their signature. Based on these rules of procedure, many individuals and organizations in the Americas present amicus briefs to the court, and such is the case of the work of both Rebecca and Silvia, which will be further discussed today. Thank you again for joining us today, and we are delighted to hear you. We will start with Silvia, and then I will proceed with Rebecca. Thank you.
Thank you, Ivonne. Okay, I will present the amicus brief that we in the Health and Human Rights Initiative are drafting and will present and submit to the court next week. Basically, we divided our amicus brief in three main arguments or in three main parts. The first one trying to address or to respond to the main legal question of the case, and the other two trying to propose new approaches to the discussion. The first one, meaning the main legal question of the case, is the balancing that we're proposing between the protection of the life of the unborn and the rights of Beatriz, and the The two new approaches that we're proposing in this amicus deal with the first one with the criminalization of abortion and the principle of legality, which is an approach that has not been that present in other cases of other treaty bodies of the UN or the European Court of Human Rights. And the other new approach that we're presenting is the non-retrogression principle, the violation of the non-retrogression principle with respect to the right to health in El Salvador. So I'm going to present these three main components of our amicus. First, about the balancing between the protection of the unborn and the rights of Beatriz. I would like to start mentioning that, unfortunately, and different from many other topics in the context of the Inter-American system, the Inter-American system is approaching the issue of abortion at a very different pace in comparison to other international mechanisms, and even slower than the developments in the Latin American region. In the UN treaty bodies, there are many cases in which there has been international responsibility on the part of the states in contexts very similar to the Beatriz case, in very extreme circumstances in which women or girls didn't have access to an abortion, and also that has happened in the European Court of Human Rights for a number of years. But this is the very first case in the Inter-American system, so it is arriving a little bit late in comparison with other international mechanisms, and slower than the developments of the region, because while the trend in Latin America is moving forward in expanding the decriminalization of abortion, even beyond an exceptions model, in this case we are discussing the most basic issue, the absolute criminalization in very extreme circumstances as the ones that Beatriz faced. That is why, in our vision, the case should be understood and decided by the Inter-American Court as the very first step of the Inter-American case law with respect to abortion, and not as one that closes the discussion. So we hope for the Inter-American Court that, even though this is a very basic case in terms of very extreme exceptions, that they use a language that will allow for further developments in the future with respect to abortion. Having this in mind, our amicus in our amicus, we offer the Inter-American Court a proposal to respond to the main legal question of the case, that is El Salvador internationally responsible for criminalizing abortion in all circumstances? And of course, our answer to that question is an emphatic yes, and we propose that the Inter-American Court deals with this legal question using the principle of proportionality. This is a methodology, the principle of proportionality, that has been extensively used by the Inter-American Court in many different cases, in cases of equality and non-discrimination, and also in cases related to restrictions of rights, especially those cases involving conflicts of rights or conflicts of interests. So we define the conflict of interest in this case as the conflict that takes place between the interest of the state in the protection of the life of the unborn on one side, and on the other side, the rights of the pregnant person when the fetus is not viable and when the pregnancy poses a risk to the life or the health of the mother. Before moving to all the different steps of the test of proportionality that we're proposing in the case, we start in our amicus recognizing and acknowledging that the interest of the state in protecting the life of the unborn should be considered as an legitimate interest. We accept that, but we argue that this is not the only relevant characterization of the protection of the life of the unborn in the case. The most relevant characterization in our perspective, beyond the legitimate interest of the state, is the one that defines and clearly establishes the level of protection that the American Convention gives to the unborn. In a previous case, in the Artavia Murillo case that many of you are familiar with, this was a case against Costa Rica related to the prohibition of in vitro fertilization in Costa Rica. The Inter-American Court started its interpretation about the scope and the extent of the protection of the right to life from the moment of conception, and it characterized or framed the protection of the unborn as incremental. But this was not an invention of the court. Some people tend to, and some of the expert witnesses during the hearing expressed their disagreement with this approach to the court, but it is relevant to recall that this was not an invention of the court, the idea of incrementality of the level of protection of the unborn in the American Convention. This is a result of one of the primary methods of interpretation of international treaty, and actually one of the methods of interpretation that conservatives tend to like the most, which is the literal interpretation of the American Convention according to the ordinary meaning of the terms, using the Vienna Convention on the Law of the Treaties. Because Article 4.1 of the American Convention establishes the protection of life from the moment of conception, that protection is in general, it means that there are exceptions to such protection. That's the understanding of the common ordinary meaning of the terms. This interpretation is also consistent with the travaux préparatoires and the history of the drafting of the American Convention that confirms that the words in general in Article 4.1 of the American Convention were intended for the convention to be compatible with domestic legal frameworks allowing for abortion. So the idea of including the words in general was for states that allowed for abortion to be able to ratify the American Convention without the necessity of presenting reservations or without creating a great conflict between the domestic legal framework and the American Convention. So it is not only the literal interpretation of the treaty, it is also, there is also a corroboration and a confirmation of that literal interpretation with the history of the drafting of the American Convention, which is that type of corroboration of the primary methods of interpretation is derived directly from the Vienna Convention on the Law of the Treaties. So all of this means that the life of the unborn, while protected under the American Convention, has a lower level of protection under the treaty. So we proposed that these two basic framings of the protection of the unborn, as on one side as a legitimate interest of the state, but at the same time as a differentiated protection with respect to persons born alive, as key to approach the analysis of proportionality that we're proposing when such protection conflicts with the rights of the pregnant person. So the first step in our analysis based on those general framings is the step of suitability. That is the link, the logical link between the legitimate interest of the state and the means to achieve that legitimate interest. The question here in the suitability step that we're proposing is whether the absolute ban or the absolute prohibition of abortion is an adequate way to protect the life of the unborn. We respond to this question saying that the evidence shows that the crime of abortion doesn't really, in practice, prevent abortions from occurring. Abortions will still take place, even in the context of very severe criminal laws, but in unsafe settings and in conditions putting the lives of women and girls at risk. So the second step of our analysis is the step of necessity. And here I clarify that although this is a step-by-step methodology, we propose to the court a whole and a comprehensive proportionality test because we don't know in which step the court will find that the prohibition will fail. So we prefer to propose a comprehensive test of proportionality. And that's why I'm going with suitability, necessity, and strict proportionality. So the second step of our analysis is the step of necessity, that is the existence of alternative, less restrictive means to achieve the same legitimate interests of the state. And here we focus our amicus in all the alternatives that the states have at hand in order to prevent the real problem here, which is unwanted pregnancies, and therefore prevent, of course, abortions. Different from criminal law, of course. So we argue that well-designed policies, including access to information, access to contraceptives, the prevention of sexual violence, and comprehensive sexual education are much more effective ways and much less intrusive ways than the use of criminal law, and particularly this type of use of criminal law, this absolute type of use of criminal law. And the third step of our analysis is the step of strict proportionality, that is the actual balancing that has to take place between the legitimate interest of the state, of the protection of the unborn, and the impact that the total criminalization of abortion, with a specific emphasis on in the facts of the case of Beatriz. So here we remind the court that that lower level of protection that I mentioned before, as a result of the literal interpretation of the American Convention, must have direct implications on the weight that the court have to assign to that side of the scale in performing the balancing exercise. So we argue that the court needs to approach to this balancing acknowledging that lower level of protection that comes from the literal interpretation of the American Convention. And we emphasize on the other side of the scale in this balancing test, the rights of Beatriz that were at stake in the specific case, where, as Ivonne was mentioning, two extreme circumstances were in place. On one side, the fact that the fetus was not viable posed an extreme risk to Beatriz's mental health and to her personal integrity to an extent that has been framed by other international mechanisms as at least cruel, inhumane, and degrading treatment. So the continuation of this type of pregnancy with an absolute absence of hope of having this child to live after birth created for Beatriz circumstances in which she faced cruel, inhumane, and degrading treatment. But it was not only the lack of viability of the fetus because of Beatriz's health condition, as Ivonne also described. She had an autoimmune disease. The pregnancy itself created a risk to her life and to her physical health. So that means that the rights on the other side of the balancing were no less than her life and her health. And we frame these extreme circumstances of the case as an acceptable burden that the Salvadorian laws imposed on Beatriz. This idea of an acceptable burden have been the basic principle behind most of the developments in Europe and most of the developments in the context of Latin America, in which judges and courts have progressively decriminalized abortion. The idea of the unacceptable burden that women have to face in this type of context. So we frame the discussion as an unacceptable burden that the Salvadorian laws posed on Beatriz. And the result of all this balancing test, of course, it is well detailed in the amicus brief, is that the total ban on abortion in El Salvador disproportionately affected the rights of Beatriz, and therefore it must be declared incompatible with the American Convention. And in addition to these arguments that are very specific to the facts of the case, we also mention in our amicus brief that the analysis of proportionality, in case that the Inter-American Court would like to make a broader analysis of the use of criminal law on abortion in general, we think that the Inter-American Court cannot avoid the general question of maternal mortality and the public health problem that these type of bans create. And we also argue that in the analysis, in the general analysis of proportionality of the use of criminal law in the context of abortion, that type of analysis cannot avoid also the discriminatory impact, the disparate impact, and the disproportionate impact that such bans pose in poor and in the most poor and the most vulnerable women. So this is basically the way in which we propose that the court deals with the basic question of the case in terms of proportionality. And as I mentioned before, the courts will hopefully receive this proposal because they have been using proportionality as a methodology to decide difficult cases in many other judgments. So the second part of the amicus deals with, and now I'm moving forward to the most novel questions that have not been directly addressed by other treaty bodies or by the European Court of Human Rights in the other cases. One of these questions is the question of legality. The Constitutional Chamber of the Supreme Court of El Salvador have been arguing for a long time that there is no actual ban there is no actual total ban on abortion in El Salvador. And what they say is that the analysis must be done in a case-by-case basis after the abortion has taken place. So they are proposing an ex post analysis of whether that abortion was legal or was illegal. The basic argument on the part of the Constitutional Chamber of the Supreme Court of Justice, and that argument was also presented by the state in the hearing, is that if your life is or health is at risk, basically you must take the risk of facing criminal charges, and in such context argue that there was a state of necessity. So using the general exceptions on criminal law in the context of an actual trial. We respond to this, which we consider very flawed. We respond to this in our amicus with two arguments. The first one is that it is mainly a lie, or it is a trap from the state of El Salvador, hiding the actual intention of the state to maintain a total ban on abortion in the country. This is because realistically, no one and no health professional will carry out an abortion knowing that there is a high risk of facing criminal charges. This was exactly the case of Beatriz. After knowing that the fetus was non-viable and that the pregnancy posed a risk to her life and health, Beatriz clearly expressed that she wanted an abortion. And her doctors agreed, and there was a medical committee stating that an abortion should be performed in the specific case, but they couldn't do it, and they were terrified because of the risk of facing criminal charges. So they even tried to obtain an authorization on the part of the Office of the Attorney General in this specific case, and social authority didn't provide for any type of certainty that they wouldn't face criminal charges if they were to perform the abortion. And even after that rejection on the part of the Office of the Attorney General, Beatriz, with her lawyers, they tried another venue in order to obtain any type of legal certainty for her to proceed with the abortion and for the health workers to proceed with the abortion. She tried a constitutional action, and in the context of that constitutional actions, the courts didn't provide any type of assurance to Beatriz or her doctors either. So therefore, the main proposal of the state of El Salvador is for doctors to perform these abortions with the risk of facing criminal charges, which is in practice another unacceptable burden, not only for women, but also for healthcare workers. And the second argument is that in response to this approach of the Constitutional Chamber of the Supreme Court of El Salvador, is that maintaining a high level of ambiguity in criminal laws is in tension with another human right, another right that is protected in the American Convention, which is the principle of legality. There is a well-established case law on the part of the Inter-American Court of Human Rights about Article 9 of the American Convention, which is the principle of legality. And specifically, there is a line of that case law that deals with the need for crimes to be clearly defined as clearly as possible in order for members of society to have enough forcibility. The principle behind the principle of legality is the idea for criminal laws to be foreseeable, for you to know what is legal and what is illegal, and for you to be able to decide about your behaviors based on that knowledge and that possibility. So we argue that in the specific case of the exceptions for abortion as a crime, the solution of the analysis in a case-by-case basis in the context of an actual trial and when you're already facing criminal charges after the abortion has taken place, clearly conflicts with this idea of foreseeability of the use of criminal law and the punitive power of the state. And the third part, and this is the final part of the amicus brief, deals with the principle of non-retrogression, and specifically with respect to the right to health. We make this argument because in El Salvador, for those who are not familiar with it, before 1997, the criminal code provided for some exceptions with respect to the crime of abortion. It was not an ideal model, of course, and the language was not ideal in terms of how those exceptions were framed in the criminal code, but at least there were some exceptions provided for in the criminal code before the reform of 1998, after which the total ban was in place. So the principle of non-retrogression is a very well-established principle in international human rights law, and especially with respect to economic, social, and cultural rights, including, of course, the right to health. We argue in our amicus that this change in the law from 1997 from a not ideal, but at least some type of an exception model in the criminal code to a total ban had a great impact in the right to health of women in situations similar to the one that Beatriz faced. That constitutes a retrogression contrary to the principle of progressive realization of the right to health. We acknowledge that this is an approach that could face some challenges, as the notion of progressive realization is usually, and the common understanding of the notion of progressive realization is usually tied to those components of the rights that depend on economic resources. But there is nothing in the comparative judicial or quasi-judicial practice with respect to the principle of non-retrogression that suggests that it cannot be applied to other dimensions of social rights, including the right to health, such as the dimension of liberty or autonomy to decide on health treatments, which is the case of total bans to abortion or other health treatments. Thank you.
Thank you, Silvia, for this presentation on the three main arguments of the amicus brief that presented by the O'Neill Institute that will be presented, that basically address the balancing test, the elements of suitability, necessity, and strict proportionality, the use of criminal law and the principle of legality, as well as the principle of non-retrogression and the right to health. Now we will proceed with Dr. Rebecca Cook, who will explain the arguments presented in her amicus brief. Thank you.
Thank you very much, Yvonne. I want to thank the O'Neill Center and Oscar Cabrera in particular for arranging for this session. I think the ability to hear from Silvia about her brief, particularly since she hasn't finished her brief, is that correct?
We are still working on it.
Good. I have some ideas. I have some ideas because in rereading my brief and rereading the commission decision in preparation for this meeting, I would redo my brief in some ways. And I'm hoping that you might be able to make some corrections. Correct my mistakes in your brief. So let me explain. So the brief that I did was really trying to remind the court of its rich jurisprudence around prejudice, stereotyping, and stigma. And I want to acknowledge Yvonne and the Center for translating it into Spanish. So the Inter-American Court and the Commission have a rich jurisprudence around prejudice, stereotyping, and stigma. It starts with the Cotton Fields case and goes up until last year in the Lozado case, is that right? Lozado versus Bolivia case. So I wanted to remind them of this rich jurisprudence and suggest some ways that they could apply it in the Beatriz case. I also wanted to explain, just to remind the court about prejudice, stereotyping, and stigma, so they could understand this phenomenon, not in the context of abortion, but in other contexts in which they've ruled, and hopefully triggering their imagination about how they might apply it in the Beatriz case. Thirdly, I wanted to think about the obligations that states have in addressing the prejudice, stereotyping, and stigma that takes place in the health sector and in the legal sector. So the rich jurisprudence of the court, as I've explained, started with the Cotton Fields case. It proceeded with the Atala case, a case of a lesbian woman not being able to have custody of her children. The Espinoza case about a fair trial of a woman in jail. Then in the IV versus Bolivia case, the non-consensual sterilization of a poor refugee woman. Then it goes last year, the two most recent cases are one on obstetric abuses and one on sexual abuse of an adolescent. What is very difficult for courts to do when you come to prejudice, stereotyping, and stigma is to name the prejudice, to talk about it, why it emerges in certain sectors, why it doesn't in other sectors. So I spent quite a bit of time, and I think too much time in my brief actually, and then I'll get back to that, talking about naming. I thought very carefully about the kinds of prejudice and stereotyping that arise in the health sector, and I tried to name them. To give you a sense of the importance of naming, perhaps the court that's done it the best is the Colombian Constitutional Court in the 2006 case on abortion, where they talked about women as reproductive instruments. So they're treating women as reproductive instruments and not as people in and of themselves that have integrity, equality, and dignity. So they prejudge women and treat them according to that reproductive instrument. Now, the significance of that is that naming of the stereotype, treating women as reproductive instruments, because it was so well done, has really stuck. And it was brought up in the commission case, and it's brought up in many other cases. So as lawyers advocating before courts, and as judges determining these cases, we have to be very, very clear about how we name these prejudices and stereotypes. We have to talk about them in lay terms that people can understand. Treating women as reproductive instruments. I mean, that's a clarion call. So in this brief, I talked about, and I'll just talk about a few of them, women lacking capacity to make their own decisions. I think I'd say now lacking capacity for free and informed decision-making. Treating women as reproductive instruments, I referred to the Colombian case. Women lacking credibility. There are quite a few decisions of the court where, because women lack credibility, they don't need to listen to them. Then making unmeritorious requests for healthcare or legal relief, because you can treat women as not in and of herself, you can ignore her request. Perhaps most importantly, what I wish I had done better in this brief is to talk about the compounded nature of stereotypes. So in this book on gender stereotyping that I did many years ago with Simone Kuzak, a former student, we talked about sex stereotypes, sexual stereotypes, sex role stereotypes, and compounded stereotypes. Now, compounded stereotypes are not well thought through, but they're very, very important in this case. And this is really building upon the work of Shreya Attry on intersectional discrimination. Yes, in the brief that I did, we cited Shreya's work on intersectional discrimination, what she calls doing intersectionality. But her scholarship analyzing the decisions of the Human Rights Committee and how the Human Rights Committee fails to do intersectionality is absolutely brilliant. It first came out in the journal of the Nordic Journal of Human Rights, and she updated it, and it's being reprinted in a forthcoming book that I edited, Frontiers of Gender Equality. Shreya's work on intersectionality is really pushing the boundaries. It's pushing courts, it's pushing advocates to think far more clearly about intersectional discrimination. So in this case, you've got Beatriz. Yes, she's poor. And the commission makes a big deal of the fact that she's poor. But in rereading the case, and maybe we can discuss this later, rereading the case, was it poverty that was the ground that was most significant? Or was it her pregnancy? Or was it her underlying condition? And I wish in my brief, and maybe when you argue on discrimination in your brief, you can talk about whether it was actual poverty, because this woman did have access to healthcare. I mean, and you had doctors saying that she should get it. You had doctors saying that she didn't have it. You really had a conflict among doctors in the case. But it was the inability of doctors to deal with her pregnant status. And we haven't, I think, one of the missed opportunities in litigation and policymaking around maternal mortality is we fail to acknowledge women's pregnant status and how courts, how health service providers, how the health sector tends to suspend women's rights when they're pregnant. What is that phenomenon? What is the prejudgment when woman is pregnant that we can suspend her agency, that we can suspend her rights? There's something going on there, and we need to name it. Maybe it's because most doctors are male, they've never been pregnant. Maybe it's because women are vulnerable when they're pregnant. But this needs to be teased out and thought about far more clearly. We have a prejudgment of women who are pregnant. We have a prejudgment of pregnant women whose rights can be suspended during pregnancy. Why? What's going on in the health sector? So her pregnant status, to me, is a huge factor that the commission really didn't address. Secondly, her underlying health condition. Her health status. So discrimination on grounds of health status here. Yes, the doctors who called for the termination really considered her health status, her underlying condition, discrimination on grounds of health status. But the commission really didn't pick up on that. What was going on discrimination on grounds of health status in this case that the commission could have picked up on, that we want the court to pick up on? But most importantly, what is the compounded nature of her sex, her gender, her pregnant status, and her underlying condition? You know, the fact that we think about her underlying health condition, which was critical, as health status, should we have characterized that as a disability and brought in some of the disability jurisprudence? Question, I don't know. I raise it because in my co-author, Simone Kuzak, in her work subsequent to the book that we co-authored on gender stereotyping, she went on and did some very important reports for the Office of High Commissioner for Human Rights. And really, the way our thinking around prejudice and stereotype is advanced is, yes, through developments relating to gender, but also disability. There's a rich jurisprudence in the disability arena. And maybe we could have brought some of that in had we thought about her underlying health condition as a disability. I'm really grateful for Oscar to bringing this together. I'm really grateful that I had to reread my brief and think, oh my God, I forgot. And let me just pause before I go on and say, I do hope, Oscar, you'll bring us back when the decision is made to really debrief on the case, debrief the strategy, debrief the amicus, debrief where we need to go next, because this is a very important case. And let me acknowledge that Oscar's done this before around a very important Brazilian case on maternal mortality, death and childbirth. So there's attrition here at O'Neill Center, and I hope they'll. Okay, so thinking about the obligation to name, but thinking about the obligation vis-a-vis the compounded stereotype. And let me refer to Shreya Atri's work again and just explain why this is so important. We have to make space for the specific explanations, and I'm quoting Shreya here, of the nature of intersectional discrimination based upon multiple grounds. Discrimination as causally accruing on the basis of both sex and ethnicity, in the case of the LNP case versus Argentina, where an indigenous woman was raped, discrimination as causally accruing on the basis of sex and ethnicity that specifically related to her indigenous status, she was Kwam, which is different from the experience of others who access the criminal justice system. So why was it different? Why was it different in the Beatriz case? Well, it was different because she was made to wait 48 bloody days when she was pregnant with a fetus that had no chance of survival. What else was different about that case? What were the experiences? What were the lapses in that case? There was no protocol. She had hardly no right of appeal to that decision in the El Salvadorian law. Yes, she went to the commission, she went to the court for provisional measures, precautionary measures, but she had no bloody right of appeal to that medical decision. And that's wrong. And I'm sure in the principle of legality, you'll be bringing that out. So there are specific experiences that Beatriz, on these multiple grounds of discrimination, experienced because of intersectional discrimination. And talking about that and naming that and discussing that in very real terms. 48 days. Can you imagine? 48 days. So Shreya's work is really instructive in terms of how she does intersectionality. And this afternoon at the American Society of International Law, I'm on a panel about what international norms need thickening. Well, the international norm of intersectional discrimination needs to be thickened. And now we have some brilliant scholarship that can help us thicken it. So here's another area. I'm so glad your brief isn't done yet, because maybe you can make amends for my brief. So here's another area. I talk in the brief about stigma production. Well, I wish I had done a better job of it, and let me explain why. So you have obligations to name, you have obligations to talk about the difference of intersectional, the multiple grounds for intersectional discrimination, and how the compounded nature makes intersectional discrimination often different from just a single grounds discrimination case. But you also have an obligation to condemn the harm. So what was the harm here? The harm was the stigma production against Beatriz. Now, stigma production, and this is some work that I did criticizing a case of the European Court, the RR decision. Stigma production, and this is social science work that I'm borrowing from in this, but I think us lawyers have a lot to learn from social scientists. Stigma production and this goes to the point about inhuman integrated treatment. At base, stigma production is inhuman integrating treatment. And let me take you through the phases of stigma production. And this is based upon the work of Link and Phelan, two brilliant social psychologists. But let me back up further and say that stigma production and the work on stereotyping of social psychologists is absolutely critical to our work. And the work of the American Psychological Association in the Price Waterhouse case was bar none. I haven't seen anything that matches it. It's brilliant. The case, the amicus brief that they filed in that case really made you come to grips with stereotyping. Everybody's talking about stereotyping, but nobody knows what it is. Nobody names it as well as the Colombian Supreme Court. March forward, social psychologists have done some very important work around stigma production. And it's in part because of the stigma around HIV/AIDS. There's been a lot of work in that area, but it's really very useful. Because if we're going to think about why criminalization of abortion is bad, one issue is because of stigma. So we need to better understand stigma, because if we're going to decriminalize, what do we mean by decriminalization? Is it social decriminalization? Is it legal decriminalization? But we need to know what destigmatization means. So let me take you through the phases, and this is according to Link and Phelan's work. The first thing is to mark a pregnant woman. So how is Beatriz marked? She was marked because I think, and this is reasonable, people can differ, but I think she was marked because she was pregnant. So marking allows you to think about a woman as different. So she was marked as pregnant and therefore different. Then link that marking through stereotyping to an undesirable characteristic. So what was happening in the Beatriz case? She was marked as pregnant. Then she was linked to a stereotype of you can argue several things here, as a reproductive instrument, but also marked as somebody with no agency, with no credibility, with no ability to make free and informed decisions. Then through that linking, usually through stereotyping, to an undesirable characteristic, healthcare providers, and this is the third step, can separate her from other patients and treat her according to those derogatory stereotypes. So marking, linking, separating them. Fourthly, denying them essential health care, or delaying essential health care, in her case, 48 days. And overall, these four phases, marking, linking, denying, she is disempowered in the healthcare sector because she's a poor pregnant woman with an underlying health condition, and she's in a healthcare sector with docs, mostly men, mostly of higher class. She's poor, a woman, and pregnant, with no appeal procedures, with no protocols that allow for a fair assessment of her condition. So she was in a context of disempowerment. So understanding the stigma production in this case is absolutely critical to articulating how she was denied her right to, in the case of the integrity, to be free from inhuman and degrading treatment. So Silvia, those are some of my mistakes. Maybe you can make amends. I got in all of this, but I wish I had articulated it stronger. But Oscar was at me to get this brief in, so I tried. But it's really fantastic to have the ability to think about how you could have made a stronger case. And yes, I could have made a stronger case. So in sharing those, with hindsight, you always have 20/20 vision. But that's what I wish I had done a better job of in the case. Now, in terms of obligations of non-repetition, so we talk about obligations of naming, obligations to make space for intersectional discrimination, the obligations to condemn the harm, in this case, the harm of stigma production that led to inhuman and degrading treatment. Finally, the obligation of non-repetition. And here's where we really need to work, well, in all phases here, we need to work with social psychologists, and I have no idea whether Georgetown, University of Toronto, it's always fascinating to try to meet up with some of the social psychologists. But the legal profession has done some good work on the obligations vis-a-vis non-repetition. There is, and also the Inter-American Court is asked for education and training vis-a-vis prejudice, stigma, and stereotyping. The Canadian, we cite this, the Canadian Judicial Council has some training around stereotyping. The UK Judicial College, and then gender units of various courts in the Americas, such as Mexico and Chile, have gender units. And they've discussed some of this, very, very significant. So the legal profession is far more advanced, really. We've got a long ways to go, but they've really thought somewhat about this. Contrast the health professions. Whew. There's one guideline from the FIGO, the International Federation of Gynecology and Obstetrics, about gender stereotyping. In full disclosure, my husband was on the ethics committee and I pushed him to do this guideline. So it's only one guideline. And I'm sure, I don't know whether the American College has a guideline on stereotyping or stigma. I have no idea. Interestingly, the medical colleges of Maharashtra state in India have done phenomenal work around training doctors vis-a-vis gender. Phenomenal work. Have any of our medical schools done similar things? I have no idea. But the health professions have a long ways to go if they're really going to respect their treaty obligation of non-repetition. Because unless we have to train our professionals in terms of prejudice, prejudgments, stereotyping, and stigma, and have to take it far more seriously if we're really going to be serious about the principle of, about the obligation of non-repetition. So with that, I think now that I've laid bare all my mistakes of my brief, let's have a discussion.
Well, thank you, Doctor, again, for your presentation on the brief. I think we've heard around the analysis of discrimination in the case, how stereotyping plays a role, compound stereotypes, the analysis of intersectional discrimination, and principally the analysis of stigma production in the case and how those elements should be considered, the elements of marking, linking, separating and denying access to healthcare, and the relevance, of course, of the obligation of non-repetition and what that entails for states if they want to take this seriously. So thanks again for this presentation. I will now have some minutes for last precisions and some comments, and then we can move forward to the Q&A. I would like to remind to everyone joining us today here in person and online that you can share your questions through the Q&A tool provided by the platform where we are streaming. And also here for everyone who has a question, we will move forward in a few minutes, so start preparing them. And now, Silvia, if you have...
Yes, I would like to make some comments. Thank you, Rebecca. This was really great. I have 3 big comments that I wanted to make in reaction to your presentation. The first one is about the state's defense in the hearing, which really replicated most of all these stereotyping that we're naming here, which is usually the case. It usually happens that when there is a case of stigma or stereotyping, it is not only the actual judicial or prosecutors, judicial authorities or prosecutors or police that made the stereotyping in the first place, but also when the state defends the case internationally, they replicate those stereotyping very, very strongly. And this happened really in the context of the hearing. Why? At least three aspects of the state's defense before the Inter-American Court that replicated all those stereotyping, maybe without acknowledging them, but that they were very present in the defense of the state. One is that she didn't really understood her health condition. And that goes to the element of agency. They repeated a lot of times, and they brought a doctor to the hearing to explain to everyone what was her real actual risk, that she didn't actually had a life risk, that her life was not, there was not a threat to her life in the case. And that she didn't receive what the state is trying to say, that she didn't really receive enough explanation that her life was not at risk to the extent that she believed. So there's the topic of credibility was really present when they tried to say that she really didn't understood what was going on with her body and with her health status. The other aspect that replicated stereotyping in the hearing is that she was not only Beatriz, but also her mom, because as you know, Beatriz died a few years after this situation in a car accident. But they also sent the message repeatedly that she was manipulated by the movement in pro of abortion. So that she requested the abortion because she was being manipulated by a movement. By a social movement. So it also, the first one goes to the idea of credibility, but this one goes to the ability of agency, that she didn't make that decision for herself, but that some people convinced her to make that decision in order for her to be the face of a specific movement. And another one that was maybe I am thinking about the hearing and what I heard from the state, but they are trying to say that there should be there could be a termination of pregnancy only in the specific minute where the person is about to die. So the risk is not enough. The general risk is not enough. The grave risk to her health or the grave risk to her life was not enough. It was necessary to be absolutely sure, and that happens with many other exception models in other countries. It has to happen in the very minute where the person is about to die, and then you can perform the abortion. So that idea of imminent risk, of that extreme standard, in order for her to stop being a reproductive instrument, I think that goes to the idea of a reproductive object, because for the state, and they repeated this many times, for the state, it was not enough the risk to overcome the idea of Beatriz as a reproductive instrument. She could stop being a reproductive instrument only in the minute before she was about to die. And I think that idea of creating a very high standard of imminent risk goes to the idea of maintaining the notion of reproductive instruments. So I think that those were moments in the hearing where all those stereotyping that you're mentioning, that you're naming in your amicus, were present in the defense of the state, in the strategy of the state. And the second comment that I wanted to make is about the idea of disability. Thank you for bringing that. That's very, very interesting. And I think that there could be an option of making an allegation of her health status as disability, not as health status in general as disability, but in the context of the specific case based on the social model of disability. And I am thinking of a previous case that the Inter-American Court decided, the Gonzalez-Dewey case, which is about HIV. And it is about a girl who had HIV and she couldn't continue studying at her school. She was expelled from her school because of her HIV. And there was a lot of debate in the context of the strategy of the case whether we should name HIV as disability, because we didn't want to reproduce stigma over HIV. And people tend to think that framing something as disability means stigma, which is a problem itself. But we were debating this idea whether HIV itself should be considered a disability, and the court took a very interesting approach that could be replicated in this case. And the court said, this is a health condition. It doesn't have to amount to a disability. It shouldn't, but it amounts to a disability, or it amounted to a disability in the specific case based on the social model of disability, because there were attitudes and stereotyping about her status that created those social barriers for her. So trying that idea to the case of Beatriz, it could be possible to understand, based in the social model of disability, that the attitude barriers took place basically because of the stereotyping, and because of so the stereotyping is itself the barrier that created, or the factor that created the barriers in the case for her to receive adequate care. That's just an idea that I'm thinking here, trying to bring the debate that we had a long time ago in the context of the Gonzalez-Dewey case. And the final comment that I wanted to make is thanking you for bringing this idea of naming the stereotypes around about pregnancy, about the idea of being pregnant. I haven't thought about that before, and this is new for me. But in the context of the medical sector, there is a lot of work in the context of naming the type of biases and the type of stereotypes that take place, for example, with disability. So we understand, and now we know, and we name those stereotypes. Maybe maybe there's not a whole there's not a lot of work in terms of overcoming those stereotypes, but at least we know what are those biases that take place in the context of disability and healthcare, and also in the context of race and healthcare. But I haven't thought about it in the context of a pregnant person, and I just wanted to thank you for bringing that, because this could be a very interesting approach that the court could take in the case.
A question I have is whether, if you want to go that route in your brief, is to talk about pregnant status and how is it most effective as a strategy to think about how we suspend women's rights to free and informed decision-making when she's pregnant. Because free and informed decision-making is very much sacrosanct in the healthcare sector. Well, in some healthcare sectors, in sectors that aren't filled with doctors, paternalistic doctors who think they could make decisions for pregnant women because they don't know, they don't understand, as you suggest. So it might be, you might find in the El Salvador medical code something about free and informed consent, at least, maybe not dissent, but in free and informed consent. So the one, you kept talking about unborn life. Was there a reason for that, and not talking about prenatal life?
No.
Okay. Because I've been corrected on that point many times, because I talk about, when I write unborn life, people will cross that out and say prenatal life. Then the other point, the LC versus Peru case. So in the brief, I tried very hard to talk about the inter-American jurisprudence, but also the CEDAW jurisprudence, which is really quite good on stereotyping and prejudice. And also, I should flag the CEDAW commentary. There's a very good chapter on stereotyping in the second edition of the CEDAW commentary that's just out. So that might be of help here. The point about in your proportionality analysis, would it be beneficial to cite, I think it's the 2010 case of the Portuguese Constitutional Court, which specifically addresses risk factors for unwanted pregnancy, that instead of criminalizing abortion, they say the court has many other alternatives to criminalizing abortion, and that is addressing the risk factors for unwanted pregnancy. So that's maybe some helpful language for your brief. It's cited in the chapter by Ruth Rubio Morin in the book on transnational perspectives on abortion cases and controversies. I think that those were the 2 points that came to mind in terms of your, on disability, the person that might be helpful to you is Andrea Parra, who's done a lot, you probably know her, but she's done a lot of work on that. And also on
Submitted an amicus brief to the court.
Yeah, okay, on that issue. Okay, fine. Well, maybe using some of the best it was the Zika case. And was it the Zika case? It was the case before the Brazilian Constitutional Court, the Supreme Court of Brazil. And they had this day of where they have these open sessions where they educate the court on the issues. I've forgotten what it's called, but the Brazilian court has that wonderful mechanism of a teach-in for the court. And the person who spoke on disability from a woman's perspective at that hearing was absolutely brilliant. I don't think, Andrea might know her name, but certainly Deborah Dinitz would know her name, who was an absolutely brilliant presentation.
Well, thank you both for this last exchange, which clearly sheds light into other surrounding issues that must be considered through the briefs and the decision of the court. Now we will proceed to the Q&A. We have already one question online from, and I will start by that and then address the questions here with our public hearing person. But the first question is from Kiara Palacios. And she says, thanks for this incredible event. I would like to ask the speakers if it is possible they can dig into the principle of non-retrogression as part of the base arguments. Have there been any rulings related to this issue in the Inter-American Court of Human Rights?
Yes. Should I go?
Yeah.
Okay. Yes. There have been not a lot, but there has been an evolution in the context of the Inter-American case law about the principle of non-retrogression. First, in 2009, establishing very clearly on the part of the commission and on the part of the court. It was actually the same year in two different decisions in which both explicitly said that the principle of non-retrogression was justiciable under the Inter-American system and specifically under Article 26 of the American Convention. In that year, the Inter-American Court didn't end up applying the principle of non-retrogression in the specific case, but it responded to an argument on the part of the Peruvian state saying that it was not justiciable or an enforceable principle under the American Convention, and the Inter-American Court at least gave that first step in stating that it was enforceable under Article 26 of the American Convention. The Inter-American Commission in that same year issued a merits report that didn't go to the court because the Inter-American Commission found no violation in the specific case, and it is about Social Security. It applied the principle of non-retrogression, making explicit and it was an example that it was enforceable under the American Convention, but it said that it was a justified retrogression in this specific case. It's merits report 3809 of the Inter-American Commission on Human Rights, which really is the only detailed example of adjudication of the principle of non-retrogression in the inter-American system. So I will really recommend for you to take a look at the methodology that the Inter-American Commission used in that case to end up saying that there was a retrogression with respect to Social Security, but that it was justified in the specific case because it was the idea in the case was that they were trying to lower the higher pensions in the Peruvian system in order to improve the situation of the lower pensions. So they presented enough evidence that it was to lower the privileges of the Social Security scheme in Peru, and that was the idea of the reform. That's why the Inter-American Commission considered that it was justified, but it applied the principle of non-retrogression and the decision of violation. And very recently, the Inter-American Court actually applied it only in one case. And actually, it was a case that we litigated in the Health and Human Rights Initiative here. It's a case against Chile, and it was with respect to the right to health. And it's a case about a girl it's the Vera Rojas case against Chile. It's a case about a girl with a disability, with a health condition that was a very grave health condition. And she had a private insurance, and the private insurance decided from one day to another to take out the coverage of her in-home treatment. She needed in-home care, she needed in-home treatment with very specifications, and from one day to another, the private insurance decided to take out the coverage of that specific treatment for her. That happened because there was regulation on the part of the health authorities in Chile that allowed for that determination on the part of the private insurer. But that regulation was not in place before. So it was at some point where the health authorities in Chile decided to allow the private insurers to take out this type of medical care, and this type of deference or discretion was not in place before. So that's why the Inter-American Court said that regulation on the part of the health sector, giving the private insurers more discretion to take out, to eliminate some coverage with respect in the context of catastrophic illnesses was our type of retrogression incompatible with Article 26 of the American Convention. So those are basically the cases in the inter-American system.
Thank you, Silvia. I think we have another question that addresses specifically the presentation of Dr. Cook. So it's a question by Mariel Ortega online, and her question says, based on the arguments around intersectional discrimination in the present case, do you consider it could be argued that a norm that is sustained on gender stereotypes as the total ban of abortion, which also affects women from an intersectional point of view, to be incompatible with the principle of equality and non-discrimination? And if so, the need to be removed from the legal system to make it compatible with international human rights obligations.
Can you restate?
Yeah, so the first question is, do you consider it could be argued that a norm that is sustained on gender stereotypes, such as the total ban of abortion, could be incompatible with the principle of equality and non-discrimination?
Okay, let's just stop there.
Yeah.
Okay. So is the evolution of the jurisprudence in the Inter-American Court, and Silvia might want to chime in here as well. You started with, in the Cotton Fields case in 2009, the disappearances of women probably raped and sexually tortured and dumped in a cotton field in 2009. That court, that decision, when Cecilia Medina was president of the court, they said that the phenomenon of the treatment of the investigators or the lack of investigation constituted a stereotyping. Then you had an evolution that stereotypes exacerbate discrimination. And then you have jurisprudence that says stereotyping constitutes discrimination. Stereotypes is a form of discrimination. And in this case, in the Beatriz case, it would be wonderful, pushing here, compounded stereotypes constitute a form of intersectional discrimination. So you have an evolution from phenomenons, certain ways of treating women constitute stereotyping, and the court takes judicial notice of that. Then you have jurisprudence that says stereotypes exacerbate discrimination, contribute to it. And then you have jurisprudence that says stereotyping constitutes discrimination. Stereotyping is a form of discrimination. You have yet to have jurisprudence that says compounded stereotyping is a form of intersectional discrimination. So if you look over time, starting in 2009 to last year, you have the Inter-American Court saying it is a form of discrimination. So hopefully the court in the Beatriz case will reaffirm that the most recent part of that trajectory.
Mm-hmm. And the second consequential question is that if it could be declared incompatible, do you think it could also be declared that there is a need to be removed from the legal system to make it compatible with international human rights obligations?
This person is asking some tough questions. I wish. So for as long as I can remember, in the program at the University of Toronto, Joanna Erdman, who used to be the co-director of the Sexual and Reproductive Health Program, and we would submit amicus briefs arguing for a recognition of criminalization as a form of discrimination, using CEDAW General Recommendation 24, criminalizing medical procedures that only women need is a form of discrimination. Few courts have so argued. Few courts have so decided. Excuse me, courts don't argue, they decide. I'm ever hopeful, but that's why the jurisprudence of the court on equality and non-discrimination in this area is lacking. And I've lost count of how many briefs Joanna and I have done. Some on her own, some together. The most recent form of argument is through stereotyping. So discouraged as I was on persuading courts to decide that way, I thought, we need to step back and we need to think far harder about frontiers of gender equality. I think as a movement, we've failed. Well, not failed. We have a long ways to go. As a movement, we have a long ways to go to convince courts to think about phenomenons from the point of view of the discriminatee. So in this book that's forthcoming, University of Pennsylvania Press through Burt Lockwood's Human Rights series, we step back. And the first part of the book is thinking about understanding gender inequality and equality. Legal philosophers such as my colleagues Sophia Moreau, Sandra Fredman, have done some brilliant work on equality and inequality. And it's made me, and Shreya Atri, it's made me really think far harder about inequality, gender inequality, and gender discrimination. It's given me a lot of further thinking about where we might go. The second part of the book is looking at what treaty bodies, both international and regional, have done with equality and non-discrimination. And the third part of the book is rewriting, rethinking decisions of the court. And in the third part of the book, Charles Nguema and I rewrite a decision of the Zimbabwe Supreme Court on grounds of equality. It's the Mapinguri decision woman was raped, she was denied access to abortion. In cases of where she was legally entitled to the abortion, but we trace how she was discriminated against through that and argue discrimination. So I have hope, but we as lawyers, we as advocates, we as judges, I think have an opportunity to try to convince courts about how criminalizing medical procedures that only women need, to quote General Recommendation 24 of CEDAW, is a form of discrimination. But we have a long ways to go and we need to pull up our socks.
Let me add something to Maria's question.
We have just a very few minutes to wrap up 1 or 2 questions here and finalize the event.
Okay.
So I don't know if anyone here in the room has a question or comment.
I'm curious about a lot of what Rebecca has said about medicine and gender, because at least in the Caribbean, there has been a huge shift, both in law and in medicine, in terms of the gender composition of those professions. Yet I have seen no change whatsoever in either the jurisprudence or the medical practice. In fact, in every one of the surveys that has been done about medical opinion on abortion, a few of which I have done myself, the nurses are uniquely and consistently more conservative than the doctors. So the issue is as much about gender as about training, because the issue we have to ask is what are the social institutions that have a capture on the value creation of women in our society, so that even when they become lawyers and even when they become doctors, they make no change in the conduct of their professions.
And that's why I think training and education is so critical. And the fact that the Inter-American Court has called for that training is significant, and how we build upon that to, for example, to integrate gender perspectives into how we train doctors, how we train nurses, how we train lawyers is absolutely critical. And I want to acknowledge Anika Gray here, who is a gender specialist and is doing some of that training, or has done some of that training in the law faculty at the University of West Indies. So we have a long ways to go, but there is some progress. There is, in terms of there's one point I wanted to mention on the principle of non-retrogression. There's also a very important Chilean decision with regard to women that you might want to cite, that Veronica Unduraga cite in our comment on our chapter on health in the CEDAW commentary. I can't remember the exact facts, but it might be a useful site for you. So, you know, we have a long ways to go. And now that we do have women in both the professions, I think we can do more. But the fact that they've been trained in an old system is just perpetuating the same. But I have hope.
We are unfortunately running out of time. So what we propose to everyone here is that we close this event and we have a time to exchange our questions here in the room with a coffee and some treats we have outside, and we share more of a space afterwards. But we want to thank you again, both Rebecca and Silvia, for sharing with us these very insightful reflections on the case, on the briefs that have been prepared and presented to the court, and how it links to the analysis that the Inter-American Court will be doing for its final decision. Thanks again for your time, for being here, and thank you everyone who is joining us also online. We are very appreciative of your time, and thank you again, and hope to see you again in some other O'Neill events. Thank you everyone, and have a nice day.